Good afternoon, everyone. My name is Alexa Eggleston, and I am the Substance Abuse and Addiction Project Director for the Council of State Governments Justice Center. I want to thank you for joining the National Reentry Resource Center's webinar to review the Second Chance Act Reentry Program for adult offenders with co-occurring substance abuse and mental health disorders and the Family-Based Offender Substance Abuse Treatment Program solicitations, which were just released by the Bureau of Justice Assistance at the U.S. Department of Justice, the sponsor of today's webinar. In order to help potential applicants respond to the solicitations, we are joined by representatives from the Bureau of Justice Assistance who will explain the details of the solicitations and answer your questions. We need to pause for a brief question and answer session after reviewing the first solicitation for co-occurring disorders, and then we'll conduct another Q&A session after we review the solicitation for the Family-Based Treatment Program. To ask a question, please type the question into the Q&A panel on the bottom right-hand corner of your screen. Please feel free to ask questions throughout the webinar, and we answer them after each section as well as at the end of the webinar. We will do our best to answer your questions, but please understand that this is a very large webinar, so your question may not get answered. And we will be available after the webinar via email as well as through BJA to answer questions that may have not gotten answered during this session. If you encounter technical or audio problems during the webinar, please call WebEx Technical Support at 1-866-293239. We understand that there are some technical issues you may not be able to resolve in time to participate in this webinar. For this reason, we are recording the event, and we will be posting the recording on our website within a few days. And the website address is www.nationalreentryresourcecenter.org, and the slides, I believe, are already posted for your review. Now, I would like to introduce today's speakers. We are joined by Thurston Bryant, who is a policy advisor with the Bureau of Justice Assistance at the U.S. Department of Justice, and as well, we are joined by Dr. Gary Dennis, who is a senior policy advisor for corrections with the Bureau of Justice Assistance at the U.S. Department of Justice. We appreciate Thurston and Dr. Dennis taking time out of their very busy schedules to be with us today. And now I would like to turn it over to Thurston and Dr. Dennis to walk us through the Second Chance Act and the specific solicitations.
Alexa, this is Thurston. On behalf of BJA in our Office of Justice Programs, myself and Dr. Dennis, we want to thank you, Alexa, and the Resource Center for all your continued great work and partnership, as well as everyone in the field who continue to strive and do excellent work in terms of the reentry field. First off, we're going to talk about the Second Chance Act just for a little bit. And because we're covering two solicitations, we're going to kind of go through the slides quickly just so we have enough time to answer all the questions. So, and a lot of the information from the slides is just basically taken verbatim from the solicitation. So we want to provide you guys with as much opportunity as possible to ask us questions. So hopefully we'll have about an hour throughout all the question and answer period to kind of go. The second law in April of 2008 authorized $165 million to provide for reentry programming during fiscal years 2009 and 2010. With the overall goal and purpose to help states and communities reduce recidivism. 2009 actually marked the first year for implementation of the Second Chance Act programs by BJA. And from the initial year, we had $25 million, which was available for donation from congressional appropriations. During fiscal year 2009, actually had three solicitations. One was for the establishment of the Resource Center. One was for demonstration grants, and then the third one was for mentoring grants for nonprofit organizations. And I'm sorry, I made an error at the next bullet point. In 2010, we were fortunate to receive more appropriations from Congress for the Second Chance Act, and in 2010 we received $100 million in appropriations which included funding demonstration sites, the solicitation for that, for the mentoring program for nonprofit organizations, as well as 5 additional sections, which included the family-based and the co-occurring disorder solicitation programs. This is some links for where you can find some additional information on the solicitation. We have solicitations posted on our website at BJA, as well as we encourage everyone always to go and visit the National Reentry Resource Center's website, which provides a lot of information on the Second Chance Act, but also in terms of general reentry activities as well. So there might be some additional information on there from other federal agencies that are providing reentry activities. There's some new activities that are occurring with the interagency working group, which is related to the level working group that Attorney General Holder and some of the senior executives and leadership are operating. So I always encourage everyone to go to the Resource Center for additional information, not only on BJ activities, but just in general on general reentry activities as well. So we're going to begin by talking about Section 201, which is for the co-occurring disorders. Solicitation was released and posted on May 12th this year, and applications are due by 11:59 p.m. on June the 23rd. As always, we always recommend that applicants who are interested in applying for the solicitation do go early on. So if you this solicitation is going to be utilizing grants.gov, you can go ahead today and go ahead and sign up to receive your passwords and all of the registration requirements and get that out of the way. It happens oftentimes with different types of solicitations is if you wait that last day when the applications are due, you have certain types of issues that pop up, such as your computer freezes or your power goes out or what have you. There's really only distinct circumstances where you're probably going to be allowed to submit your application post deadline. We always encourage everyone to get that in as soon as possible. And then if you have any problems with your application, like you forgot to include some attachments or what have you, or the application was incomplete, always go and resubmit it. And what to happen is the second submission that you've provided to us is the one that would be included because that is the most recent one, and so the other one would just be discarded as a duplicate application. So here's another web link that will provide you some information on where to find the solicitation. Section 201, the purpose of that is to provide awards to eligible applicants that include states, units of local governments, and federally recognized Indian tribes to improve substance abuse and mental health disorder treatment to individuals who are incarcerated within prisons or jails, and this needs to occur pre-release during the period of incarceration behind walls, and also through the completion of parole or other types of supervision post-release while the individual is transitioning back into the community. These funds can also be used to implement or expand treatment programs for individuals with co-occurring disorders. So again, eligible applicants are states, local government agencies, and federally recognized Indian tribes. Oftentimes we get the question from nonprofit organizations who provide some types of treatment services to these individuals. Can they apply for this solicitation? The answer is no. That eligibility requirement is based on congressional language, so a nonprofit or for-profit organization could not apply for these funds. However, there's an expectation that an eligible applicant, such as a state or local government agency or a tribal agency, they will partner with a community provider, so in essence, a nonprofit or a for-profit organization could receive a sub-award from the eligible applicant to provide treatment services. So if there are nonprofits or for-profit organizations out there who are listening in on this webinar, if you already have an existing relationship with, for example, a correctional facility in your jurisdiction, it will be advantageous for you to see if they are going to apply for this solicitation and other ones to provide, treatment services for individuals trying to reintegrate into society. So under the approved uses of funding, we talk about this solicitation being for co-occurring disorders, which refers to co-occurring substance-related and mental health disorder. So it has to be a combination of those. And another example of approved funding is The funds can be used to provide recovery support services, reentry planning and programming, and then post-release treatment and aftercare programming to assist the individuals while they're trying to reintegrate back into the community. In addition, one thing that we inserted into the solicitations this year, and this one as well as the one we're going to talk about later, and then also in terms of some of the other Second Chance Act solicitations, is that we want to stress again the use or the need for applicants to follow evidence-based practices. So solicitation, you'll see that there's now information in there that applicants must demonstrate how they are going to follow 6 fundamental principles of evidence-based correctional practices, how these are going to be integrated into their program design and their project. So these are 6 bullet points on what those entail. So those would include providing objectively assess criminogenic needs, risk and needs of the individuals, so the target population, providing enhanced intrinsic motivation, targeting higher risk offenders, addressing the criminogenic needs, incorporating cognitive behavioral interventions, and applying the dosage principle as well. So you see that this same information is going to be in the next one we're going to talk about, and it's also included in some of the other solicitations that we put out this year to kind of strengthen what we're looking for. For the program design elements, applicants need to be able to address specific types of program design elements with their application. For example, they need to provide information on the screening assessment instrument tool that they're going to be utilizing within their project, information on the targeting criminogenic needs that they're going to incorporate for the project, and again, we're trying to hammer again on the use of evidence-based substance abuse and mental health treatment. In addition, there's some other program elements which should be included with the project, including transitional planning, provide information on supportive comprehensive support services for the project. The applicants also need to provide sustained aftercare and case planning and management for the individuals when they're going to transition back into the community, and also provide supervision services which follow evidence-based practices again. Regarding priority considerations that we're going to be looking for when we're making award selection and determination, applicants need to be able to identify medium high-risk offenders for their project. There's another priority consideration that will be given for projects that target female offenders, the geographic area within the jurisdiction which includes a high rates for returning individuals into the community, and also priority consideration will be given for organizations or applicants which are partnering with a resource organization to conduct evaluations on the project and their strategies. The application, or within the solicitation, we provided like a list of mandatory treatment requirements, and one which is you're probably to provide information certifying that the treatment program has been developed in coordination with the single state authority. This is information that was in the solicitation last year as well. Going on to the next, in terms of selection criteria, when the application is submitted, this is the breakdown of how the application will be reviewed and scored by peer reviewers. So the statement of the problem is weighed 15%. The program design and implementation information is weighed 35%. Capabilities and competencies 25%. By 10%, and then the information on the impacts and outcomes of the project is weighted as 15%. So I'm going to quickly go through the select criteria, just because, again, like I said, this is kind of verbatim from the solicitation. So first one is the statement of the problem. The applicant needs to provide information that describes the problem, provides information on the jurisdiction that's going to be served, also provides information on the target population, and then also provides some of the basic components of the current process for identifying the risk and needs of the individuals who are going to receive treatment. As for the program design and implementation, the project should describe the activities that address the program goals, provide some information on the analysis of the target population, describe how the individuals will be linked to different types of treatment or other recovery support services, and then describe mechanisms to ensure that the accountability of the service delivery system have been adhered to. For the capabilities and competencies and coordination section, the applicant needs to be able to describe the management structure of the applicant, the organization that's applying for the award. They also need to be able to provide information identifying the organizations that will provide treatment services to the target population. In addition, the applicant needs to be able to demonstrate the capability of the agency and the collaborative partners in terms of carrying out the project, and then also demonstrate some of the partnerships that will be incorporated within the project in terms of partnerships with community providers. In addition, they need to be able to provide some information indicating whether the jurisdiction is a current recipient of other types of BJA administered programs which might have an impact in this area, such as the RSAT program, which is a formula-based program. The next criteria that will be examined for all the different applications that are submitted is on the impact and outcomes and evaluation. And this is just basically, we're just looking for information overall, which is going to provide information on the project in terms of the effectiveness of the project and meeting the outcomes and evaluation components utilizing data collection. Next, other component that is going to be examined is the budget, which accounts for 10% of the weighted distribution in terms of how the project is going to be examined. There is no requirement for this solicitation. The other important thing to consider in terms of the budget is that all applicants should set aside some funding and estimate travel to Washington, D.C. For a couple of trips during the award period. And these are typically, like, for example, we have a Second Chance Act grantees meeting. So in essence, they need to put information within their budget regarding proposed trips to Washington, D.C. Next, the performance measures. I'm not gonna talk too much about the performance measures. We've kind of changed those a little bit from the way have been implemented within the solicitation. One, if an applicant is awarded, what we'll do is post-award period, there'll be a series of different conversations and discussions regarding the performance measures and how to record the performance measures within all the different types of data systems that we utilize. So if you do receive an award, you will receive like follow-up training on how to actually incorporate and provide information on your performance metrics within some of our data systems. But in terms of the training for utilizing those data systems, you needn't worry about that unless your application is actually awarded. Contact information for the solicitation is a little different from what we've done from years past. Normally myself and friend Gary Dennis, usually we have answered all the questions and answers from the field for all the different Second Chance Act solicitations. What we've done this year is that we have established a new center called the Justice Information Center, or the JIC Center. So if you have questions on the solicitation, there's information there, and also on the front page of the solicitation to contact JIC, the Justice Information Center, so they will address your questions and provide some answers to you. If you have any questions on technical assistance, of course, you would need to contact the grants.gov customer service hotline, so there's information there on that slide in terms of the 800 number and then the email. So this time, we can open it up to some question and answers specific to Section 201 for the co-occurring disorders.
Thank you very much, Thurston. And just as a reminder, if you would like to ask a question, please type the question into the Q&A panel on the bottom right-hand corner of your screen. Again, we're taking questions about the co-occurring disorder program, so please let us know if any questions occurred for you as Thurston was walking through the solicitation. You have one question right now. The question is, if the treatment program is contained in a unit only that provides recovery services treatment for occurring disorders and other drug treatment populations, can this be considered separate from the general population?
The answer to that is yes. As long as the folks that are in that program are all involved in some type of substance abuse treatment.
And we're assuming that question is related to the prison-based specification about within the prison, if it's a prison-based project, there's some information that is supposed to be like a separate and distinct unit from the general population. So we're assuming that that question is in reference to that.
So. A question came in about whether or not if federal agencies can apply to the solicitation, so maybe referencing sort of federal parole probation or BOP. Are they allowed to apply for the solicitation?
No, not. Unfortunately, our second chance funds have to only target state and local offenders, and they're not to serve federal offenders. The Federal Bureau of Prisons got a separate second chance appropriation for their reentry work.
That would also include pretrial services, correct?
Correct.
Okay. Would a forensic mental health community hospital, a quote-unquote locked unit, be eligible for funding?
Well, it kind of depends on how they define themselves. Since the eligibility for this is states, local government agencies, and federally recognized tribal agencies, they have to be able to define themselves as such. So, I mean, that will kind of be dependent upon what their statutory language is defining that institution.
So they were a State Department of Mental Health facility working with the forensic population. They should be able to apply.
I think we can say yes on that if it was a state agency, and the clients, the target population, were folks that were being prepared for reentry.
Okay. Have a question about how many months pre-release should programming begin? Is there a requirement or a recommendation?
There's no recommendation. We just want to make sure that the program design needs to be what is effective in providing services that are going to be needed to get these offenders stabilized and ready to be released. And of course, in mind that these funds certainly are used post-release to help provide ongoing supportive services in the community. So the answer is no. There's no specific time frame, but I think we're probably, based on my experience, that they're talking about at least probably 6 to 9 months of programming ahead.
You also don't have any kind of specific requirement or standardization for the number, like a minimum or maximum number of offenders or incarcerated individuals that each project should address. That's up to the applicant, but it also will kind of weigh in terms of the project design, the program design, and uses of funding, in terms of how a specific project is going to be weighted towards another one in terms of the effectiveness and cost allocations, et cetera.
Well,
you would.
Yeah, following what Thurston is saying, too, is that also understand that this co-occurring population is a very needy population. So it's unrealistic to see what might be considered a relatively high price tag on a project serving maybe not that many offenders because of the intensity of the services that are going to be required for them.
And you sort of account for, understand differences in terms of length of service behind the walls that would occur between a prison-based versus a jail-based program, given sort of the length of stays. Okay. Have a question about, I think, the definition of an adult offender and how it's defined. So, for example, it sounds like this individual is from, I think, New York State, where their age is 16.
For 18. 8 years of age or older.
Can this grant be awarded on a collaboration basis? For example, a state agency and private mental health company? And if so, who would be the main applicant?
Well, yeah, I mean, it's expected that there will be projects where it will include a collaboration, a partnership, with the eligible applicant as well as with the community providers. For the purposes of this, kind of going back to what we said originally about eligibility, the eligibility is for states and local government agencies and for fairly recognized tribes. So regarding that applicant, if there's like a partnership that's kind of forming or is being formed, the agency that meets that eligibility requirement, so the state or local government agency, like if it's the Department of Corrections or what have you, they are the organization that needs to apply fully for the award. And then, of course, they subcontract with the different community providers. But it's that state or local government agency, as an example, that would need to actually submit the application.
Okay. Could you verify what an actuarial-based assessment instrument is? I think they're wondering whether that would include sort of clinical substance abuse mental assessment instruments, or is it something else?
Well, the whole field of assessment in corrections risk needs assessment is evolving. What we are wanting folks to use would be some version of a validated assessment instrument. And I know there are clinical instruments that have been validated on various populations. I think of something like air psychopathy scale. Oftentimes what we talk about in our reentry work are things like the COMPASS or the LSIR, or it could be a separate instrument that has been developed by a correctional agency and been validated on their population. But it needs to be some type of an instrument that is based on actuarial numbers that are validated.
Okay. And does it have to be determining criminogenic risk, or can it be just a clinical assessment?
Because of the population that we're dealing with, we would probably expect to see some determination of criminogenic needs and risk, yes.
Okay, great. The question about in regards to the target population, the guidance indicates target population as adults with severe mental and substance use disorders. Our target population is adults with severe and persistent substance use disorders and mild to moderate mental health disorders. Is that acceptable, or must both be severe?
I think that it would depend on how the applicant described that target population and would relate to the programming that was designed to meet their particular needs. If you're talking mild to moderate mental illness, but with high level of substance abuse needs, I really don't have a specific answer except to say it would probably depend on the context of the program. I certainly wouldn't arbitrarily rule out that and say that you had to have someone who was a full-blown schizophrenic as well as some cold alcoholic. I think you use some reason there.
Okay. So a technical question, which I'm not sure if you can answer, but I will throw it out there just in case. They want to know what they need to submit as evidence that their program's development has been coordinated among the proper authorities, that the number of the solicitation is not included on their state clearinghouse's list of programs for intergovernmental review.
So is this question regarding the certification criteria, kind of like providing documentation for that?
I believe so, yes.
One page, I think it's the last page of the solicitation, where an appendix that the applicant has to sign and has to provide with their application. They got like a copy of the service provider's organization's license, their accreditation, and then their certification. So, bunch of things.
Okay, great.
One thing we're looking for is, and it could be in the form of a letter of documentation that they have coordinated with the state substance abuse agency or the state mental health agency. And for instance, if both of those were the state agency and both of those were combined in a cabinet level government agency, then a letter from the Secretary of Health and Human Services or whatever indicating that there's a collaborative effort would probably suffice for that requirement.
Okay, let's take one more question and then we'll transition into the next solicitation. Sort of a two-part, it looks like. Can a tribal authority solicit funds for pre-conviction services? Are services designated solely for individuals post-conviction whom are reentering their community?
Services are for post-conviction folks. We anticipate that the target population starts while they're incarcerated and then moves through the reentry and the post-release stage. So this is not meant as a diversionary program. It's not meant for folks who are pre-trial.
And also, they will want to ensure that that tribal entity is a federally recognized Indian tribal government determined by the Secretary of the Interior.
Okay. So just to clarify, if they are applying for a grant that will be working with a jail population, it should be a jail population that it has been convicted and is serving a sentence and is not awaiting conviction.
Right.
Okay, great. Thank you. With that, why don't we go ahead and transition into the family-based grant?
Okay. Yeah, the second solicitation that we're going to talk about is for Section 113, which is family-based substance abuse treatment programming for individuals. So the solicitation was also released on May the 12th, and again, these applications are due by 11:59 p.m. on June the 23rd. As I indicated earlier, if you have an interest in this program and you're going to submit an application, you go ahead and register to get all your passwords and all the registration information, your DUN number and your CCR number and all that. You should get that taken care of. You can go ahead and do all that now to kind of save you some time. As well as because like with CCR, that might take a couple of days. There could be a backlog. Uncertain about that, so you want to go ahead and just go do that now. Get all the registration and password information taken care of. There's a link for the solicitation, as I indicated as well. You can get on our BJA, our webpage. At the top of our main webpage, we have a tab for corrections programs. You click on that, go down to Second Chance Act. The solicitation will be listed there as well as the FAQs. Want to also suggest there's some FAQs that have already been developed for this one and the one we previously spoke about. And in addition, want to advise you to go check out the National Reentry Resource Center's website, because that contains information on all of our Second Chance Act solicitations, as well as other general reentry information. And then the great thing about that is that myself and Gary, we don't keep like a personal listserv. So if you go to the National Reentry Resource Center's main webpage, lower right-hand corner, there is a hyperlink. Click on that. You can sign up to receive the free electronic newsletter. So like whenever we release solicitations, we coordinate the Resource Center. They send out like a blast email telling you about the solicitation that is on the street. When the webinar's coming out, they send out a blast email to all of their subscribers. And you know that there is a webinar coming out. If there's something else, like another webinar on reentry activities that pertains to substance abuse or housing, just kind of like a general information kind of a thing, they send out information on that. So it's a great way to get information, get up to speed, especially if your area and your organization are focused on reentry specifically. Section 113 of the Act is to provide awards to eligible applicants, which include states, units of local governments, and federally recognized tribes. And the purpose of this is to provide substance abuse treatment services to individuals who are incarcerated, pre-release behind walls within prisons or jails, and post-release for individuals who are the parents of minor children. In addition, services can be provided to the family members for those individuals. And when we say family, we don't have a specific encompassing operational definition for family. Family can include a broad range of different things. It could include an aunt or an uncle. It could include the significant other. So there's some information solicitation about what family could possibly include. So as I said, I would check that out to kind of make sure that what you're going to do is going to be allowable. Eligible applicants, again, states, units of local governments, federally recognized tribes, and the same applies for this section 113 as it did for section 201. Nonprofit organizations are not eligible to apply directly for this and receive funding from us. However, there is an expectation that partnerships and collaborations with community providers will occur. So, for example, at Department of Corrections, if they receive an award, they have a relationship with a community provider, they can provide a subcontract or sub-award with a nonprofit organization for treatment services. Moving on to approved uses of funding. So this section, solicitation, is for Fund to develop, implement, or expand family-based treatment programs for individuals incarcerated with minor children, and then also to provide treatment services and outreach to family members as well. Funds cannot be used for any individual parents for whom there is a real evidence of engagement in domestic violence or child abuse. Continue on, as I indicated in the previous Section 201 solicitation, we've tried to reemphasize the importance that projects include evidence-based practices or evidence-based principles. So, again, we are reemphasizing that these projects need to demonstrate how the 6 fundamental principles of evidence-based correctional practice have been integrated within their projects. And, again, these are the 6, which are the same as the 6 that I referenced in Section 201. The program elements are also similar to Section 201. Like you see, the program design elements for the proposal need to include a risk needs assessment instrument, target criminogenic needs that affect the recidivism for the target population, providing evidence-based substance abuse and mental health treatment, providing family-based and pharmacological drug treatment and other types of services, providing transitional planning procedures for the population, provide support of comprehensive range of different types of support services, providing sustained aftercare and case management planning to assist the individuals returning to the community, and also providing community supervision services which follow evidence-based procedures. Regarding priority considerations for under Section 113, the applicants need to, in order to receive priority consideration, they need to identify and target medium to high-risk offenders. They also need to be able to focus on the geographic areas which include high rates of returning individuals from confinement facilities. Also, in order to receive priority consideration, the application needs to demonstrate how those 6 evidence-based strategies, which we mentioned earlier, are going to be incorporated into the project. It also provides information on an independent evaluation of the program. The mandatory requirements, this is similar to what we discussed in Section 201 as well. The applicant needs to be able to provide a treatment program certification and also provide documentation that the project or the program has been developed in coordinating with the single state authority for substance abuse. And some additional requirements that the application needs to be able to provide. So the application needs to provide information indicating how the minor children and family members will be identified, contacted, and engaged in different types of service provisions, and also provide information on integrating different types of techniques to assess the strength and needs of the individual and their family to receive treatment programming. The awards amounts for this section, for Section 113, there are 2 different categories that you can apply under. Category 1 is for state or local government agencies, which are going to be serving incarcerated individuals. These are for adults. Category 2 is for tribes. This is a little bit different than what we did in the previous section, but applicants need to apply under 1 or 2 categories. And the award amounts are for up to $300,000 over a 24-month period. This is the next slide. This is a breakdown of the selection criteria, and similar to the pre-solicitation that we discussed, there are 5 different components which will be examined regarding the selection criteria for the application. So the first area is the statement of the problem, which is weighted 15%. The second is on the program design and implementation, which is weighted 35% of the total scoring for the application. The third component is regarding the capabilities and competencies and the coordination of the project. That is weighted 25%. The impact and outcome information is weighted 15% of the total scoring. And then budget, lastly, is going to be weighted 10% of the overall scoring for each individual application. application. So we're going to kind of talk briefly about all these 5 different selection criteria areas. And like at the end, if there's any questions on those, please feel free to ask myself and Dr. Gary Dennis about any other questions you might have about that. But this is pretty much, like I said, this is straightforward from the solicitation, so we didn't want to spend too much time going over these verbatim. So in terms of the statement of the problem, in this area, the selection criteria, the applicant needs to be able to explain the inability of to fund the program adequately without receiving any federal assistance. Also, the applicant needs to describe problems with meeting the family and the substance abuse treatment needs of the individual who have minor children and who are attempting to return home to the community. Well, it indicates that under the statement of the problem, that the applicant needs to provide information on the target population. Also, the applicant needs to be able to determine and summarize some of the basic components, identifying the risk and needs of the offender, and as well as the family needs for the services that are going to be provided. And that's about it. There's some additional information that might be in solicitation and assist you in that area. The second selection criteria area is the program design and implementation. And here the applicant needs to be able to describe the activities that address the overall program goal for the project. In addition, they need to be able to provide any information on the analysis of the target population that's going to be served with the funding request. Also, they need to be able to provide information on how the individuals will be linked to different treatment services and also to different types of recovery support services. Moving on to the next slide, additional information that needs to be provided under this category, under the selection criteria for program design and implementation. The applicant needs to be able to provide some information on the participating family members, and how they will be identified, engaged, and linked to treatment services, describe services that will be excluded from the members if there is reasonable evidence to believe they have engaged in domestic violence or child abuse, and describe, these are some bullet points below that needs to be able to describe some of the legal requirements that they need to adhere to under the application. The third criteria area is for capabilities and competencies and coordination. So in this section, the applicant needs to be able to provide information that describes their overall management structure, identifies their organization and how they propose to provide treatment services to the individuals during pre- and post-release activities, demonstrate capability to implement the project and cover with different types of partners, demonstrate the partners that they are going to establish with different types of community providers, and also provide some information describing how their project be augmented with existing BJA funding, again, reference with the RSAP program, which is a formula-based program for the residential substance abuse treatment program. The selection criteria category is for the impact and outcomes, evaluation, and here again, as kind of briefly stated in Section 201, the applicant need to be able to provide information identifying their goals and objectives for the program development, their implementation, and outcomes through the use of different types of data collection. Lastly, the fifth area, which will be examined within the selection criteria, is the budget. There is no requirement under Section 113, similar to Section 201. In addition, the applicant needs to make sure that they have estimated and put information in their proposal for a couple of trips to Washington, D.C., and again, these would be for any types of conferences, training, and technical assistance meetings that might occur. The performance measures, we won't get into those too much. There's a part where those could change, and as I indicated earlier as well, if an application is selected to be awarded, we will provide some post-award information in terms of how to go about uploading your metrics into our different databases, and then provide some specific training from some of our partners on the performance measures. kind of, I didn't want to go through all those different sides of the performance measures, but that information is in your solicitation, as I indicated. We'll also kind of base on that later on if you're actually awarded. This is a couple of links to some resources to kind of assist you on evidence-based practices and treatment resources to kind of assist your project if you need some further assistance. And then the last couple of slides, again, this is the contact information. If you need assistance in terms of technical assistance, you can contact the grants.gov customer support line. There's a phone number and there's an email there as well. If you have specific questions about the solicitation, contact the Justice Information Center, the JIC Center. We brief them on all the different information for the solicitation. They're helping out tremendously in terms of providing outreach quickly and efficiently to the field in case there's different types of questions that might arise from all of our various types of second chance act solicitations. And with that, we'll open up for questions and answers if there are any. Also, the last two slides, there is a slide on the National Reentry Resource Center again. We highly advise you to check out their website. There's a lot of great information on there, not just on BJA funding opportunities or BJA in general, but just on federal reentry activities in general. So we all recommend whenever myself or Gary get questions or we get calls, we always reference whoever the requester is to go and examine the Reentry Resource Center. And then the last slide is just our website. If you want to check out our website in case your organization has different types of needs that are specific for reentry, you can also just get on the BJA website, and there's a whole host of different types of funding opportunities and resources to assist them if it's just general information across the criminal justice spectrum. So with that, we will open it up to questions from the field.
Great. Thank you, Thurston. Again, just a reminder that if you would like to ask a question, please type your question into the Q&A panel on the bottom right-hand corner of your screen, and we will try to get to as many questions as we can. Could you clarify once again whether or not the funds can be used for individuals who are on probation, who are convicted but have never been placed into custody of a jail or prison?
No, not.
Okay.
So we're looking for, again, our comprehensive program, so there needs to be the pre- and the post-release component. So if you're just looking at post-release, it needs to include both, so as Gary said, no.
Okay. Nonprofit company under contract to run all the state correctional health services programs apply for this grant?
No. The State Department of Corrections would have to be the applicant agency and the fiscal agent for the grant.
Okay. Even their current contract authorizes the nonprofit provider to request grant funds for the state correctional health services.
The state must be applicant and the fiscal agent.
Okay, thank you. Can the funds be used to treat a batterer after conviction? So I'm assuming someone that's been convicted of domestic violence.
Probably not.
Often incarcerated parents lose their job and their housing. Can funds be used for some time to pay for rent to enhance reentry?
Yes, the funds can be used post-release to subsidize rent, potentially even to subsidize employment. The only caution I always provide is that when you start subsidizing rent and you start subsidizing services and what like that, the money goes very, very quickly. But the answer is that would be an allowable use of the money.
Great, thank you. This could be used to either develop, implement, or expand programs that could possibly already be in effect. It does not have to be a new program, correct?
That's
okay, great. Could you clarify in terms of the allowable uses if faith-based services can be funded as part of the grant?
Well, I think that we certainly encourage faith-based organizations to be part of collaborative efforts. I think that we have to be aware of the separation of church and state issues. would it be appropriate for a faith-based private nonprofit in the community to provide some type of family counseling services or supportive services? Yes, as long as the religious element was not injected into that. The separation has to be there. As far as the faith-based organization being a provider, being a subcontractor, sure. In fact, we encourage that.
And then for the faith-based organizations, there's some information in our OJP financial guide. It also might be referenced near the solicitation. There's some bullet points on some additional requirements. I think one of those is pertinent to that, to faith-based organizations. So, and there should be a hyperlink there as well. So if you click on that hyperlink, that'll take you to a financial guide, and there's specific requirements in there for for a faith-based organization. So examine that as well.
Do you know how many awards are going to be available for each grant?
I think probably in the neighborhood. Our funding was cut back this year. I think in one category we made 22 last year and 123. I'd say in each of these two categories, probably around 15 awards.
We can't always give like a definitive answer on that, just because, for example, for the award amount, we see up to, I think for section 201 for the co-occurring, it's for award amounts up to $600,000 for a period of 24 months. Then for section 113 is for award amounts up to $300,000. So that doesn't mean that every application is going to be for $600,000 under section 201 for the co-occurring. You might get somewhere for $300,000, just because based on what their program design is and what their project is. So it kind of varies. So we can't really. That's like why it's always just an estimate about how many we kind of think we might be able to fund.
In regards to the family-based grant, if the children were placed in foster care following the parent's conviction, is the parent still considered a custodial parent for purposes of the grant?
The program design brought the family back together. The whole purpose of this is to bring family units together and begin to strengthen them pre-release, recognizing again that substance abuse is often a destabilizing factor in the family. So I see why children who are in a foster care setting, you have to also bring the foster parent. I'd say that as long as family units, people could be kept together, that certainly, on the program design and commitments, should be workable.
Great, thank you. Okay. There are other questions. We still have a few moments. Please, again, if you have questions about either the first solicitation we discussed, the co-occurring disorder solicitation, or the family-based solicitation, we can take questions on either. Please type the question into the Q&A panel on the bottom right-hand corner of your screen. Okay, a question about residential community corrections facilities, which contracts with DC and meet correctional requirements and vacations, but do not have state Department of Health, Substance Abuse, or mental health licensing. DOC does not require those certifications. Can they be a sub-grantee? In a nutshell, even if they're not a state licensed facility, be a sub-grantee to a grant.
I think that I'm going to approach this the same way I would procurement. Our position generally is that if in doing a contract, the state agency or local agency, as long as they follow their procurement procedures in awarding that, and if the state agency indicated that they had consulted with the state health agency, state substance abuse agency, in the development of the overall program, and then they were going to subcontract with this private person, and it within their operating procedures to be able to use this program provider, even though that person may not have full certification, I think that would probably be acceptable.
Okay. Another question. The State Department of Corrections funds a transitional and diagnostic program for pregnant women. The women in this program are sentenced to the program and live in incarceration in jails or prisons. Could the state apply for funding for this type of program?
I think it would depend to some degree on what type of facility they were housed in.
Okay.
They were sentenced to the Department of Corrections, but they were housed in a secure, semi-secure facility. As long as they had been actually committed to the Department of Corrections, I think probably so. Because I think key to what you said there was sent us to a residential program, alternative to being sent, let's say, to the main women's prison. I think that would work, Thurston.
Yeah.
Okay, great. Other questions out there that participants would like to ask while we have sort of Dr. Dennis and Thurston on the line? Of course, as they said, your questions can also be answered via the staff at the Reentry Resource Center, as well as through the contact information that Thurston mentioned earlier. Another question, I think this is similar to the one that I just asked, but let's ask it again just to make sure that everyone's clear. If the provider has a contract with the Department of Corrections but is not required to contract with the state substance abuse licensing or mental health licensing agency, not consult with them, can they be a sub-grantee?
The onus,
So it's a little different.
the onus for consultation and coordination is really on the applicant agency. The agency would have to provide the Department of Corrections evidence and proof that they consulted with the mental health and the substance abuse people. You know, the bottom line is that we do not want to in any way, shape, or form support or whatever the disconnect that already exists among agencies out there. So this is just given that we may get 100, 130 applications or something for this, and we're going to make 15 awards. Those folks that are going to rise to the top are going to be the ones that clearly have established those linkages and have brought their state mental health and their state substance abuse agencies into the fold. So I think a lot of these types of questions are really central in, given the particular organization of the state or jurisdiction. But the key factor here is that the applicant agency has got to provide the documentation that collaboration and coordination has taken place at the state level.
Great. And then you repeat once again the deadline for the co-occurring disorders solicitation?
Applications need to be in by 11:59 p.m. Eastern Time on the 23rd, I believe. And sometimes, make sure that you realize that's Eastern Time, because I know there's a couple incidents like where an applicant is in the Central Time Zone and they submit at 11:59 p.m. Central Time. Well, we know that's an hour late Eastern Time, so they would have missed it. So all information is on the front page of each of our solicitations. So it'd be 11:59 p.m. Eastern Time on June the 23rd of this year.
Okay. Another question in order to apply for a program that a jurisdiction may be just developing, is there a time frame in which that program has to be fully implemented underneath the grant?
I recognize the fact that most folks are not going to know until sometime toward the end of September. All of our awards have to be made by October 1. We normally allow for a 2 to 3 month startup period. And in our programs, it's standard procedure to grant a 3-month no-cost extension simply because of the startup issues.
Also, there could be some special conditions which are attached to the application I'd have to address before they actually receive funding access.
Okay, great. And with that, it looks like no additional questions are coming in. I just want to, again, thank Thurston and Dr. Dennis for taking time out of their schedules. I want to thank all of our participants for attending and participating. And, of course, again, thank you to the Bureau of Justice Assistance for sponsoring this event. Would encourage you to take please participate in the survey questions that will pop up on your screen after the webinar ends. Really helps us sort of guide the development of our webinars. And again, just want to remind you all that the recording of the presentation and slides will be available in the next few days on our website at www.nationalreentryresourcecenter.org. Thank you again, Thurston and Dr. Dennis.
You're welcome.
Yeah, thanks again, Alexa and our friends over at CSG and the Resource Center, and also to everyone who was listening in. And as I said, if there's any additional questions, you can contact our Justice Information Center. You can also contact the Resource Center. And again, we always encourage people to leverage resources. So one of the neat things that's on the Reentry Resource Center website now is the National Criminal Justice Initiative map. So you can click on your state, see what federal programming might be in your state or in your jurisdiction that you're not aware of. And we always encourage people to leverage resources. Just, there might be some additional funding opportunities with some of our other federal partners like the Department of Labor or Health and Human Services or Department of Education. So we always encourage you to check out their websites as well to see what might be available just so you can leverage all your potential pools of federal funding resources and kind of plug in all your gaps and needs. So with that, my friend Dr. Gary Dennis and I will sign off, and then we hope to see you again. If there's anyone out there actually who's listening who has an interest, we're going to have a webinar for the demonstration Section 101 solicitation. That's going to be next Wednesday afternoon. So if you have interest in that, come back and listen in, and we will see you then.
Thanks again, and this concludes our webinar.
Right.
Thanks.
Bye-bye.
Bye.